Good morning. Thank you for joining us for today's webinar. My name is Hannah Booth and I'm the Communications Manager here at MorePay. It's my pleasure to introduce the topic to you for this morning, which is HR and employment law trends for 2024. This morning, our guest speakers, Jackie and Amy, will cover key topics you'll be facing in HR in 2024. So, moving on to our agenda for today. Jackie will begin by taking us through the trends we forecast for the year ahead, and Amy will then talk you through new legislation coming this year. She'll also discuss some recent pieces of case law and what we can learn from them. And then finally, Amy will also walk you through some upcoming bills and proposals that we can expect in the medium term before we move into our Q&A section. Now, in relation to the Q&A section, after the main presentation, we'll run through as many questions as we can. You may have noticed your microphone is on mute, but we do want to hear from you. Please drop your questions into the question panel shown here. We've had an incredible response to this webinar, so I imagine there will be lots of questions, but Jackie and Amy will do their best to get through as many as they can. Another note, if you are facing technical difficulties, don't worry too much. We will be sending you all a recording and a copy of the slides. However, if you are facing technical difficulties, please do flag us in the question panel, because if lots of them come flooding through, I'll know there's an issue at our end and I'll do my best to try and fix it for you. Before I hand over to Jackie, I'm conscious that we will have people on the webinar this morning that aren't familiar with MorePay, so I'll give a very brief introduction. We provide payroll and HR software, as well as outsourcing services to UK businesses. We've been around since 1966, have all the accreditations you'd expect, and we're rated excellent on Trustpilot. Our promise is to make payroll and HR easy, and here's how we do it. We've built payroll and HR software that's easy. We deliver quality outsourcing options, and all of this means worry-free compliance for businesses. On the side, you can see some of the businesses who trust us to take care of their payroll. So now let's meet our presenters for this morning. I'll start by introducing you to Jackie. Jackie is a non-executive director at Zellis, which is MorePay's parent company, and she currently combines her role at Zellis with her Chief People Officer role at EMIS Health. Jackie has over 3 decades of specialist knowledge of the challenges businesses face every day, from diversity, equity and inclusion to well-being, talent management and digital employee experiences. And moving on to Amy. Amy is an employment law advisor at MorePay. She has experience in working with both employers and employees on a range of contentious and non-contentious matters, and has practical experience in advocacy and casework for employment tribunal cases for both claimants and respondents. So that's everything from me. We will now move into the main body of the presentation. I'll just make sure that Jackie is unmuted so that you can all hear her. Good morning, Jackie.
Good morning. Can you hear me, Hannah?
Yes, we can all hear you. Thank you, Jackie.
Oh, apologies. I had a few challenges getting on, but I'm on my phone, so as long as I'm coming across loud and clear, that's good for me.
Yes, we can hear you.
Oh, thank you very much, Hannah. So I would like just to give, this is very much a perspective, a personal perspective on what lies ahead in 24. So forgive me if some of the things that are on my agenda are not necessarily on all of your agendas, and I'll give you a little bit of context to where I am as well on things, so you can understand where I'm coming from. So I'm going to talk through 3 main areas today that are on my in my thoughts for 24. So just a little bit of context. I as Hannah said, as introduced me, I'm the Chief People Officer for a company called EMIS Health, and I'm also the non-exec director at Zellis. And Zellis, as many of you know, own both MorePay but also Benefex, which some of you will be aware of as well. In my day job, in my role as Chief People Officer of EMIS, we were acquired by United Health Group in October of last year. So the challenges for us in the next year are probably similar to many companies that are going through a significant amount of change. So one of the things I'm going to talk about is dealing with the change agenda. But then also widening it out. The two other areas that I think that are most on my mind at the moment are hybrid working and also how we deal with the whole AI revolution. So we'll start with hybrid working. We'll look a little bit at AI, and believe me, I am not an expert on that area, so you're not going to get expertise, you're going to get sort of a sharing of some of the concerns that I have going forward and some of the things that I'm grappling with. And then thirdly, I'll look at supporting employees through change. I've worked in HR for, just to give a little bit of background, for 37 years, so a very long time. And in fact, I'm due to leave EMIS at the end of May, and probably moving into a non-exec focus in my career. So I can also hopefully answer some questions, giving some perspective over many years, but I certainly wouldn't regard myself as an expert on too many of the areas. So let's come first then, if we can, Hannah, to hybrid working. And the slides really are just to kind of prompt me and remind me of the things that I was thinking of when I first thought about this session. And this was brought to mind recently, actually, because I was looking, it's probably a couple of weeks ago, there was an article in the Sunday Times written by somebody who I went to university with. So it's a guy called Richard Harpin, who was the who founded HomeServe. Many of you will know that organisation. And he had some really interesting points to make, and so I have stolen a couple of his points actually here. And he used a phrase which was "make an office worth the commute," which I thought was interesting. And he also talks a little bit about satellite offices. And I think that the gist of what Richard said in the article, and I would really agree with this, is that there needs to be really a complete rethink around where your employees are going to be working. And I'm seeing quite a lot at the moment where companies are being very much driven by sometimes a very strong personality, maybe the CEO, maybe the CFO, who wants people to work in a particular way. So there's a sort of a push for people coming back into offices, or a pull back into an office from somebody who has quite a traditional way of thinking about things. I think sometimes companies are also following the herd a little bit. So they're looking at what other organizations are doing and thinking, okay, well, everyone in that company's back 3 days a week, so we should look to do that. And what Richard was saying is, you've got to think really in a more creative way, but where are your employees living? What would make the most sense? Is there a small location that you could where you could rent a smaller office for people to kind of collaborate? Because collaboration, I think everyone recognises, is important. But I think trying to, and I've said that, don't just roll back to a pre-pandemic world. I think it's almost impossible to imagine employees wanting to go back to exactly the world that they were in pre the pandemic. We all have a different way of working. Some people, I'm pretty much remote working most of the time. There was very little chance of getting people to literally go back to the way they were before. And actually, why would you not take this opportunity to do something different? But when I say about not following the herd, I think one of the things we're going to try and do over the next year is think about, how do we differentiate from what other people are doing? Because it's increasingly going to become an important part of your recruitment and your retention strategy if you can be slightly different perhaps in the way that you're working and what you're offering from some of your competitors. So I'd really think hard about that. Think about where the action is, encourage collaboration. And then Generation Z, which I had to actually look up to make sure that I was right about Generation Z, because I kind of forgot the years, but basically people born between 97 and 2012 will make up probably about 27% of the workforce by the end of 24 is the estimation there. So really thinking about what did that group of people, they're a significant part of your workforce, what do they need in terms of hybrid working and ways of working going forward, and focus your thoughts about how to meet the needs of that really significant group of employees, and probably in many cases not people who want to be sat at home for the whole of their working time. So hybrid working, big focus for us. So moving on to the next area, I'm conscious of time as well, Hannah, so I'm trying to keep to 15 minutes. So for AI, there's lots of stuff around at the moment, and I think sometimes this can be very overwhelming. And for those of you that have also been working for as long as I have, you'll actually remember this is unbelievable to most people, I'm sure, but the launch of the World Wide Web, believe it or not. And I remember being hadn't been working for long when people were talking about the web and what this was going to bring. And I remember making a comment which is I couldn't see it taking off, which was quite an interesting comment for me to make at the time. But I think it can be overwhelming when people start to talk about something as vast and as different from where we've been before. And I would just say for this year, certainly my focus is to be trying to find out as much as I possibly can about what can this do to help me in my role, what can it do for the HR function to help us be more effective. Ask your suppliers, what are they doing? Xalis and Morpay are ahead of the game. They have lots of really interesting ideas about how they'll bring this into their systems to really make things more effective for all of their customers. So don't be afraid to ask the people that are suppliers to you, what are you going to do? How are you going to employ this? And this could just be the turning point for HR, where we leave behind the mundane and the pieces of work that seem to take forever, and take us away from the value added work that we really want to be doing. So, in the world of recruitment, what can you do using the technology to sort of really streamline the process, and to mean that actually your time is focused on the piece of activity which is where you add value, talking to potential candidates, really understanding getting the right person to your organisation, not so much sitting and screening CVs. So there's going to be areas in every part of our world that will be made easier by this. So I think don't be overwhelmed by it. Ask your suppliers what they're doing so that you make sure that you're gaining anything you possibly can, and just think of all of the things that you could do differently as a result of the technology. And then the final part, if you just flick over, Hannah, to the final slide. So supporting employees, and really simple points, but I have really come to realise this, I guess, being part of an acquisition. EMIS are a very small organisation, so we're 1,400 people in the UK and India. It may seem like that's quite a big company, but the company that have bought us, United Healthcare, are actually bigger than Microsoft, so absolutely enormous, 400,000 employees. Trying to manage change for our employees through that period is really making me focus on thinking through exactly how we support our leaders to lead through the change. Not everything is going to be clear and straightforward. There's going to be a great deal of uncertainty for us over the course of the next year, and just trying to build a degree of resilience, allowing people to ask questions, but know that they won't always get the straightforward initial answer, and that almost having to live and work with some of the uncertainty is really important. So Hannah, I think that is the last slide, but if there is another one, then just flick through. I think we're done, are we?
This is the last slide, yep.
That is the last slide, yeah. So that they're my three sort of main things: is focusing as you'd expect on hybrid working, thinking around AI, and then also managing employees through change. That's 24 for me. I'm really happy to answer any questions or anything specific there, but also wider points. And I'd love to hear from people if they've got some magic answers in some of those areas as well. But thank you for the opportunity, Hannah.
Thank you, Jackie. That was really insightful. As Jackie says, please do start to drop your questions into the Q&A panel, and we will run through all of these questions at the end. So we will now move on to Amy. She's going to take you through the legislative landscape for this year. So Amy, we will now hand over to yourself.
Okay, fantastic. So I'm going to be talking you through some of the new legislation coming into effect this year. So there is quite a lot of information to get through. So I'll just be giving you sort of a broad overview just so that you're aware of some of the main changes. But if you do have any further questions, please let me know at the end, or if you're a Morpay client, then please give the advice line a call to discuss it in further detail. So moving on to the first one, this is in respect to the Workers' Predictable Terms and Conditions Act 2023. So currently, this is expected in autumn 2024, so around September, October time. And in a nutshell, it introduces the right for both workers and agency workers who work unpredictable working patterns to request more predictable terms and conditions of work in relation to working hours, days and times. It will also affect workers who are working on a fixed term contract of 12 months or less, allowing the worker to make a request for the contract term to be extended beyond 12 months or to become permanent. The wording of legislation somewhat mirrors that of the flexible working rules and regulations that are currently in place, so some of this will sound familiar to some of you. So a worker will be able to make up to 2 applications in a 12-month period for this, and in order for the application to be valid, it must be in writing, specify the change applied for, and specify the date on which is proposed to take effect. It should also explicitly state that it's a statutory predictable working pattern. If you do receive one of these requests, you are obligated to respond to this in a reasonable manner and must do so within 1 month from the date of the request. The Act specifies that if the request is accepted, then you must offer the worker a new contract reflecting the change relating to the working pattern. So you can reject these requests, but only if one of the statutory grounds apply. These are similar to those listed for flexible working. And these are either that the burden of additional costs would be too high, it will have a detrimental effect on the ability to meet customer demand, it'll have a detrimental impact upon the recruitment of staff, it'll have a detrimental impact on the other aspects of your business, there is insufficiency of work during the periods the worker proposes to work, or it doesn't fit into planned structural changes. So like with flexible working, if a worker is dismissed or suffers a detriment as a result of making such a request, or if you fail to handle these requests correctly, then the worker will be entitled to make a claim to the employment tribunal. So it's very important you treat all such requests on their own merits and in a reasonable manner. So the compensation for this hasn't been confirmed as of yet, but is likely to be limited to 8 weeks pay, subject to the statutory cap. ACAS, they are due to publish a code of practice on this later on this year, which details best practice for handling such applications from workers. So just keep an eye out for that when it does come in, when it is published. So if we can move on to the second one, just want to change the slide. Okay, so this the second change you should be aware about is some changes to the Equality Act, so specifically in regards to sexual harassment. So these changes are due to come into force in October later on this year. So the headline change is that it introduces a duty of employers to take reasonable steps to prevent sexual harassment of employees in the course of their employment. Currently, there's no definition of what reasonable steps may be, and it's likely we are going to have to wait for case law in order to understand how this is interpreted by the Employment Tribunal. There is currently a statutory defence for employees facing the claim of any type of discrimination in place under the Equality Act. And this applies where the employer can demonstrate that they took all reasonable steps to prevent a perpetrator from committing the alleged discriminatory acts. So currently I expect that the reasonable steps under this new legislation may be interpreted in a similar manner, but this isn't guaranteed. If there is found to be a breach of this duty, then the Employment Tribunal will be entitled to uplift any compensation by 25%. So it's very important that we need to be taking sort of due care with any allegations of sexual harassment from October, just because of this risk here. I guess in order to prepare, we would recommend that you take sort of the following steps now. So just to review and update where appropriate any existing sexual harassment policies, and make sure that you have a clear path for reporting complaints, and that the detail of reporting such complaints are easily accessible for all employees. And if you do receive any complaints of this nature, we would recommend that you do seek advice, just to make sure that you're handling them and sort of investigating them in an appropriate manner. Okay, so if we can move on to the third one. Okay, so the next change is some changes in regards to existing employment rights. There's three major changes under this new act. These are in respect to holiday pay, 2P, and the working time regulations, and will come into effect at varying points throughout 2024. So the changes to holiday pay will come into effect for leave years starting after the 1st of April. So one major change, or I guess it's a confirmation under these new rules, is in respect to calculations for holiday pay for irregular hour workers and part-year workers. So the changes confirm that holidays for these employees should be calculated based on the 12.07% of hours worked. So in order to calculate entitlement for workers who have been employed for 1 year or more, you'll need to calculate the average hours worked in the past 52 weeks and then multiply this by 12.07%. And this should then give you the annual statutory holiday entitlement in hours. So the government has proposed that for any workers who have less than 1 year's service, that you do this sort of calculation initially after each month of service. So you'll need to calculate the hours worked in the previous month and then multiply this by 12.07%. And then this should give you the monthly statutory entitlement in hours. I believe MorePay will be updating the holiday calculation details on their website. So this will be available online at a later stage. The second major change regarding holiday pay is in respect to rolled up holiday pay. Now, rolled up holiday pay refers to the method for compensating employees for their holiday entitlement by including holiday pay within their regular hourly rate or salary, instead of paying employees separately for time taken off as annual leave. It's then rolled up and distributed evenly throughout the year or pay period. So this practice was initially ruled as unlawful in 2006. However, under these current changes, the government has now confirmed that it's a lawful additional method for calculating and paying holiday pay for regular hour and part-year workers from the 1st of April 2024. So in a nutshell, from April, it now means that you can pay such workers holiday pay at the time that the work is done, instead of it being paid at the time that the holiday is taken. And then the third change is in respect to carrying over of annual leave. I say changes, but what I mean is it's sort of taken the current rules in respect to carrying over annual leave, which has been derived from cases of EU case law, and then it's sort of been ratified and confirmed into current UK legislation. So from April, it's now formally confirmed that employees will be able to carry over annual leave for a maximum period of 8 months if they've been unable to take this due to long-term sickness. It's further been confirmed that employees will be entitled to carry over 4 weeks of holiday pay each year if the employer has failed to allow holiday to be taken. So that is if you haven't given the employees a reasonable opportunity to take leave or encourage them to do so, or if you fail to tell them that if they don't take leave, it will be lost. So it's very important you have in place clear systems and processes communicating the employees that they have a right to take annual leave, and sort of encourage them to take this leave and explaining that they'll be lost if they don't take it. So as I've mentioned sort of previously, there is also going to be a change to some of the 2P regulations. So these actually came into effect from January of this year. And essentially it now means that there's no longer a requirement for employees to consult collectively with representatives during a relevant transfer if they have less than 50 employees in the company, or if it affects less than 10 employees regardless of the company size. And that's the only change to 2P, so it's actually quite a nice straightforward change to normally a complex area of law. There's also some minor changes to the working time regulations. If you can just skip to the next slide, please. So minor changes to the working time regulations. These, as with the 2P changes, they've already been in effect since January of this year. And it now effectively means that you don't need to keep, well, there's no longer a requirement for you to keep daily records of working hours. And instead it's sort of left at your own discretion as to what records should be kept and how. It is important to note that you'll still need to evidence compliance to the regulations. So I would still recommend, regardless of what this change states, that you should still keep accurate and detailed records if you can, to avoid any sort of potential issues in the future. Okay, so the next change is in respect to flexible working, and these changes will come into effect from so the 6th of April. The changes will give employees a day one right to make a request, meaning that they no longer need to wait until they have the required length of service in order to do so. It'll also allow employees to make 2 flexible working requests in any 12-month period, as opposed to just the one. The employees, when making the application, will now no longer be required to have to explain the effect that the change will have on the business and their work. And employees will now need to make a final decision on a request within 2 months instead of 3. All other rules regarding flexible working, so the reasons for refusal, and everything else will remain the same. So if we can skip to the next slide, please. So another change, quite a major change, is in respect to the Carers Leave Act 2023. So currently this is due to come into effect from the 6th of April 2024. And ultimately it would give employees the day one right to take 1 week's unpaid leave in every 12-month period in order to arrange care for a dependent with a long-term need. So under the Act, dependent is defined as either the spouse, civil partner, child or parent of the employee, or somebody who lives in the same household as the employee, or someone who reasonably relies on the employee to provide or arrange care for them. And then long-term care need is defined as either a disability, as defined by the Equality Act, an illness or injury, so that's either physical or mental, that requires or will require care for more than 3 months, or care for a reason connected with old age. So if an employee wants to make a request for carers leave, they'll need to give notice that is either twice the length of the leave being requested or 3 days, so whatever's longer. So if an employee wants to request 1 day's unpaid carers leave, they'll need to give three days notice. Whereas if they want to take 4 days carers leave, they'll need to give 8 days notice. So it's whatever's longer in the circumstances. So there'll be no requirement for the leave to be taken consecutively, and instead the employee will be able to spread out the leave over the 12-month period. The notice doesn't need to be given in writing, but the employee should still notify you that it's carers leave and the days that will be taken. So you can't reject a request if it's eligible. You can only postpone it if you consider that the business will be unduly disruptive if you accept the leave. So if you go back to an employee and advise that it's the request is being postponed, you have to do this in writing within 7 days, and explain sort of the reason for the postponement and suggest alternative dates for the leave to be taken. And you must allow the employees to take the leave within 1 month of their original application. It's quite a few different changes coming into effect under this new act. So if you do have any requests from April of this year, I would recommend you seek advice just to make sure that you're sort of handling the initial ones correctly and appropriately under the act, if you can do. So if you can, yeah, thank you. So the next sort of piece of legislation is in relation to tips. So this will really only affect businesses in the hospitality sector, and it's due to come into effect from early 2024, so around May. It's not yet been confirmed. In a nutshell, this places a requirement on employers to ensure that the total amount of qualifying tips, gratuities and service charges paid at a place of business of the employer is allocated fairly between employees. Employees must now pay the qualifying tips to the employees no later than the end of the month following the month that they were paid by the customer. It will also place a requirement on employers to have a written policy regarding the treatment and allocation of qualifying tips, and employers will now also need to keep a record of tips and their distribution for a period of up to 3 years from the date they were received. It also gives employees the rights to request information about how tips are paid to the employer and to other employees, which you are obligated to respond to within 4 weeks from the date of the request. I think it's important to note as well that the limitation period for any claim relating to the allocation of tips can be brought up to 12 months after the alleged failure of payment. So this is sort of longer than the usual 3 months less 1 day for a claim of this type. So I've sort of broken down these changes for you, but the wording of the Act, if you read it, is quite complex. So if your business is likely to be affected by these changes, again, I'd strongly recommend that you seek specialist advice about this prior to May 2024, just to make sure you've got correct processes in place in order to sort of comply with the rules under this Act. Okay. So the final piece of legislation that you should be aware about is the Protection from Redundancy, Pregnancy and Family Leave Act. So this is currently due to come into effect from the 6th of April of this year, and ultimately it extends existing protections relating to maternity and redundancy to encompass more groups of people. So the people who will now be covered is pregnant employees who are on, who have returned from maternity leave. And the protection under this Act starts from the moment that you're notified of the pregnancy and ends 18 months from the date of the child's birth. It will also cover employees who've recently suffered from a miscarriage, and the protection will start from the moment that you've been notified of the pregnancy and ends 2 weeks after the end of the pregnancy. So that's for pregnancies ending before 21 weeks, 24 weeks, apologies. For any other pregnancies that end after 24 weeks or in the event of stillbirth, there are separate rules and regulations. So if you find yourself in such a situation, I would recommend that you seek advice on that particular situation. Protections will also be extended to employees who are on, who have returned from adoption leave, and the protection will start at the beginning of adoption leave and ends 18 months from the date of placement. It'll also cover employees who are on, or have returned from shared parental leave. So it also applies to, or will cover fathers or second parents who've taken adoption leave and also share parental leave. So the protection has very much been extended. The protection here will start from the beginning of shared parental leave and ends either at the end of the shared parental leave if less than 6 weeks is taken, or 18 months from the child's date of birth and more than 6 weeks is taken. And ultimately, under this Act, employers are sort of required to give eligible employees at risk of redundancy priority access to suitable alternative roles or redeployment opportunities over other sort of employees who are at risk. So you need to make sure you're sort of treating them appropriately from April. Okay, so that's the end of sort of the new legislation for this year that I think you need to be aware about. If we could just skip to the next slide. So there are some changes in some of the normal sort of payroll rates. So from the 1st of April, national minimum wage will increase. So for employees who are 21 and over, it's increasing to £11.44 per hour. For those in the 18 to 20 bracket, then it's increasing to £8.60 per hour. And then apprentice rates and employees who are 16 or 17, pay is increasing to £6.40 per hour. There'll also be an increase in the statutory minimum payments. So these will increase from the 7th of April 2024. So statutory maternity pay, shared parental pay, adoption pay and parental bereavement pay will increase to a maximum of £184.03 a week. There'll also be an increase of statutory sick pay, which will increase to a maximum of £116.75 a week. Okay. So I'm just going to talk you through a couple of pieces of case law for 2023. So as you can imagine, there's so many cases every year. So I've sort of picked out the ones that I think that are quite sort of interesting or the most useful in the circumstances. So the first one is Linsky against Direct Line Insurance Services. I thought this was quite an interesting one, and it sort of addressed the question as to whether or not menopause symptoms can be considered to amount to a disability under the definition of the Equality Act. So in this case, the claimant had performed her role well for several years until she began to suffer from menopause symptoms, which resulted in an adverse effect upon her performance. Due to the drop in performance, the respondent refused to pay a pay rise to the claimant, disciplined her for performance concerns, and placed her on a performance improvement plan. So the claimant later made a claim for disability discrimination, failure to make reasonable adjustments, and other matters following her resigning from her position. Now, in this case, the Employment Tribunal found in favour of the claimant and awarding her £65,000 in compensation. The Tribunal confirmed that the symptoms from her menopause fell under the definition of disability under the Equality Act, and as such, the respondent should have made reasonable adjustments for her and considered this as a potential factor in the performance improvement process. So I should note that this was just an Employment Tribunal claim, so it's not binding per se on other cases. However, the outcome of this case is still important to note. So you should take into consideration any more menopausal symptoms that an employee is suffering from if it has an impact on their performance. So the next case is the Chief Constable of the Police Service in Northern Ireland against Agnew. So I'd say this is probably one of the biggest cases of 2023, and it involved sort of a group claim brought by a trade union on behalf of it's around 3,700 employees against Northern Ireland Police Service in respect to the underpayment of holiday pay. So in this case, the claimants argue that they've been underpaid holiday pay as the calculations used by the Northern Ireland Police Service were based on their basic pay, so their normal salary, and did not take into consideration their normal pay, which would have included basic pay, overtime, and then other sort of allowances. The underpayment claims dated all the way back to 1998. The respondent in this case attempted to argue that the claims were out of time, as they previously made correct payments, which had broken the series of underpayments. So as such, it was out of the 3 months less 1 day limitation period. So this case went all the way to the Supreme Court, who found in favour of the claimants and confirmed that an interval of 3 months between underpayments or a correct payment in respect of holiday pay does not constitute a break in the series of underpayments, and as such, employees were allowed to issue claims for the underpayments even if there was a gap of more than 3 months between. So it's important to note that this case itself, it doesn't affect the 2-year time limit. So if you find yourselves on the end of one of these types of claims, the maximum amount of time that a claimant can go back is 2 years. So that hasn't been changed since this case. So the next one is the case of Smith against Surridge and others. So this is, again, it's not actually an Employment Tribunal case, but instead a libel case, which was dealt with in the High Court. I just thought this might be quite an interesting one as it concerns references, which is rarely something you see full claims for. So in this case, the claimants were 2 teachers who had reference requests made by a prospective employer to their previous employer. In the reference request, the previous employer was asked whether there had been any allegations or concerns relating to the safety and welfare of children or relating to behaviour towards children. To this request, the previous employer advised that there had been some safeguarding issues during the employment, despite the claimants advising there had been no safeguarding findings made against them. As a result of this reference, their job offers were withdrawn, which then led to the claimants making their claim. So in their case, the claimants argued that the reference to some safeguarding issues inferred that they had abused and mistreated pupils and that they had been found guilty of misconduct. The previous employer rejected this and instead advised that they responded truthfully to this request after a review of email correspondence sent by them, the language in which used about the pupils amounted to concerns for them. So they advised that they were responding appropriately to the reference. So when considering this case, the High Court found in favour of the claimants. So the court found that although the previous employer did communicate concerns broadly in keeping with the reference request, the way in which it was worded, referencing that there had been some safeguarding issues, did reasonably suggest to the hypothetical reader that the claims had done something which caused harm to a child. So it was further confirmed by the court that any reference provided for an ex-employee must be true, accurate and fair, as well as factual and objective. They can't be misleading, malicious, or contain any sort of inaccurate information. A comment was further made by the court in respect to verbal references, which stated that the same sort of principles and rules apply to these. They further advised that verbal references cannot truly be given off the record. So just moving forward, you should be mindful of responding to any reference requests for previous employees, making sure that you record accurate information. It's probably safer, in all honesty, to give sort of standard reference confirming dates of employment, instead of advising on concerns that you had that weren't disciplined or investigated fully. So the final case is in respect to the claim against the National Bank of Greece, and this was in regards to unfair dismissal. So the claimant in this case had over 2 years service and was dismissed for allegations relating to gross misconduct following investigation and disciplinary proceedings. Decision was then upheld by the respondent following an internal appeal by the claimant. So following a dismissal, the claimant proceeded to make various claims to the Employment Tribunal, including claim of unfair dismissal. In her claim, the claimant contended that the procedure followed by the respondent in respect to the disciplinary was incorrect, and as such, her dismissal was unfair. So in this case, the internal process followed by the respondent involved an investigation meeting chaired by the office manager, who then referred the matter to disciplinary. 2 disciplinary hearings followed this, and these were chaired by the risk manager for the respondent, who made notes and referred the matter back to the office manager to review and make a decision on the outcome. So that's sort of the key thing here that the claimant was focusing on. So the fact that the individual who chaired the disciplinary hearing did not make the ultimate decision and instead referred it back to the investigating officer to review and make a decision at that point. And in fact, in this case, it was the office manager who confirmed dismissal on the basis of gross misconduct. The claimant appealed this decision internally, and the chair of the appeal hearing was the respondent's HR director, who ultimately upheld the original decision to dismiss. So not only did the claimant sort of argue that the person who made the disciplinary decision did not chair the hearing itself, she further argued that the investigation and disciplinary stages were blurred, and that instead the risk manager who chaired the disciplinary hearing should have been the one to investigate if the office manager was to be the one who dismiss. Now, normally good practice, it does dictate that all stages of the hearing are to be chaired by separate impartial individuals. So on the face of it, the process followed by the respondent in this case does appear to have its flaws. Interestingly, however, the Employment Tribunal found that ultimately the process and procedure followed by the respondent, although at times was imperfect, was ultimately fair. And a key factor in its decision was the existence of the appeals hearing, which was actually in fact chaired by an individual who played no part in the process prior to this appeal. And they advised that the existence of this appeal corrected the earlier imperfections in the disciplinary process. The claimant appealed this to the Employment Appeals Tribunal, who confirmed that the decision made by the tribunal was correct, and confirmed that although good practice dictates that ideally the decision maker will be present at the disciplinary hearing, but if they're not, then dismissal is not automatically considered unfair. The AT further went on to advise that dismissal processes, including any appeal, must be looked at as a whole when considering unfairness. And in this case, again, as confirmed by the Employment Tribunal, they advised that any earlier procedural unfairness in the initial decision to dismiss was sufficiently addressed by the internal appeals process. So I think in this case, it very much highlights the importance of having a robust appeals process in place, and making sure that you follow your procedures and processes in regards to appeals. So that's it in regards to case law. The next sort of point, or the next part of the slides, will be in respect to upcoming legislation, bills and proposals. So one of the things we should be aware about is the Neonatal Care Leave and Pay Act of 2023. So this is currently expected to come into force in April of next year. And ultimately, it will grant the parents of newborn babies who are in hospital for 7 days or more in the first 28 days from birth the right to take neonatal leave and be paid for up to 12 weeks. Currently, it's looking as though the eligibility will be similar to that of maternity. It's intended currently to be a day one right, but the right to receive the statutory neonatal care pay will require 26 weeks of service and average earnings on average of at least £123 a week. And that hasn't been confirmed yet, that's just what we expect. Second thing that you should be aware about is that there are some amendments to the paternity leave regulations coming into effect at some point this year. So there's sort of three major changes under these regulations. It will now include allowing paternity leave to be taken in the first 52 weeks after birth, as opposed to the current rules which specify that it's to be taken in the first 56 days. The changes will also mean that employees will only need to give 28 days notice their intention to take leave, as opposed to the current requirement of 15 weeks notice. And one last significant change is in respect to the entitlement period. Changes will mean that the 2-week leave can be taken as 2 separate blocks, as opposed to requiring that it's taken as consecutive weeks. And that's it for the upcoming bills and proposals. I think it's important to note that a lot of this will hinge on the results of the next general election, as both sort of all parties have made various sort of suggestions that they will be making changes. So I can't really confirm at this stage if there's anything else which is in the works. But yeah, thank you. That's it from me for now.
Thank you, Amy. We'll now move into the Q&A session. So I'll start off with some questions that we've received for Jackie, and then I'll move on to some questions that we've received for Amy. So let me just have a quick look. Right, so first question for Jackie. Do you think AI in talent acquisition could create issues with diversity and inclusion?
That's an interesting question. I would have thought, from what I've seen so far, that it would potentially eradicate some of the current issues that are there. So I'm interested to know what in particular someone might be thinking. My sort of overall feeling is that it will actually enable us to kind of, in a not more non-human way, if you like, in a more impartial way, to kind of see where we have issues and to sort of find ways around them. I mean, I don't know a huge amount about how it worked, but so far that's what most people are talking about, that it should actually help to take out some of the human bias that we end up inevitably having in the process. But yeah, other than that, I couldn't add much more than that, I think, at this stage.
Thank you, Jackie. Next question. Any tips for challenging CEOs with traditional views of office working?
Yeah, that, you know, that is the nub of the issue. That is such a good question. And it will absolutely come down to the relationship between, you know, if this is coming from an HR lead, it's the relationship that you have with your CEOs. I have definitely in my career worked for, and in fact not that long ago, worked for somebody whose view was definitely that everyone should be in the office all the time. It was a UK business. I think it was easier to run it in that way than perhaps it is internationally. But I would actually try, if you don't have a relationship where you can just say this is absolute madness and we're going to lose a lot of people and that person will accept that, I would be using as many other ways of trying to influence. So definitely we get a lot of information from surveys, so we can certainly use information about that. Before we made any changes on hybrid working, we surveyed the employees, and we really were very specific about that. So we left the CEO in no doubt where people's views were. So I would definitely try to sort of take away the emotion by really giving them as much information as possible, trying to find out what your competitors are doing, and then trying to suggest something that would be a differentiator for you as a business. I think is also important. You know, CEOs at the end of the day will be very commercially driven. So if you can describe exactly what that differentiator is and how you may be able to employ people more easily if you have a slightly different stance and a slightly more flexible approach. But you know, it's not easy. There's definitely a lot of companies in London where they are, I know, just dictating that people go back in 3 and then increasing to 4 days. And I think some of those are driven by people who you know, frankly lack trust in the way their employees work, and I think it's a shame. But yes, you will all, as HR professionals, have a sort of battle on your hands if you've got a very intransigent leader. But don't give up on it, because it's about developing a way of working for our longer term future. We've only been in this for 4 years, and we've still got so much further to go in getting something that really works. So I'd say just don't give up on that.
Thank you, Jackie. That's really useful. We'll move to one final question for Jackie. Can you give some examples of how we can make the office a place employees want to work in? So I think
That's also a really good question. Yeah, that's also a really good question. And I think really analysing where people live. So this point about satellite offices, so many of decisions I think at the moment are being driven by where you have offices already. And I understand it's difficult to get out of long leases, etc. But trying to work out where do you have most employees, where would they really want to be? And then one of the things that we did was we took a couple of our smaller offices and converted them in, we call them collaboration hubs. You can call them what you want really, but they're not about people just going in and sitting at a desk. The whole design is around meeting, open spaces, opportunities to socialise, opportunities to be together. So really sort of just rethinking and it doesn't have to be hugely expensive. You can have a rethink about the way in which your offices are furnished without a huge amount of money being spent, and just kind of flipping it around to something which is thinking, where do people really want to collaborate? How do they want to collaborate? Bring in the sort of social side and really encourage people from that point of view to come back in. That's what we've done. It seems to work. It seems to work well. But I'm sure lots of people in the audience will have loads of other examples of things they've done to make it attractive. But you know, make the commute worth the while is a really nice way to think about it.
Thank you, Jackie. Right, we'll now move on to some questions for Amy. So Amy, first question that we've had through for yourself is, does the Worker Protection Act also apply to agency workers?
So I believe it does in the circumstances. I mean, the actual wording is employees. However, from looking at the regulations, I believe that it will also apply to workers, so agency workers and any other, workers part-time or regular who are in your employment. So I believe that the purpose of it is to extend protections to all staff members in your employment. Yeah.
Thanks, Amy. Next question, is there any difference between carers leave and leave for dependents?
So there is. So the Carers Leave Act, it essentially extends the definition of dependent. So it's, as I said, it's also covers a parent of the employee or anybody who lives in the same household as you, or someone who relies on you to provide care or arrange care. So that would also encompass someone who lives outside of the household. So they don't technically have to be dependents in the sense where it's just spouses and children. It can be essentially anybody who fits under the definition. So it does extend extend that. So there are some differences, yes.
Thanks, Amy. And next question, for protection from redundancy, does this cover paternity leave as well, or is it only relating to maternity?
So it doesn't cover paternity leave. That's not noted as one of the protected groups. However, it can technically cover fathers or second parents who are taking or on adoption leave, or those who are returning from shared parental leave. So it does extend it in a way to fathers or second parents, and extends it beyond sort of the maternity and the mothers taking maternity leave.
Thanks, Amy. We also have had a few more questions around the protection from redundancy. So does this apply to those who are currently on maternity leave and recent returners, or will it only apply to those who notify leave from the date that the new legislation actually comes in?
So there are currently in place protection for those who are on maternity or coming back from maternity. After April, it will extend the protection timeframe to starting from the moment you're notified that the employee is pregnant, up until 18 months from the date of the child's birth. So there are currently in place protection for those on maternity leave or who've just come back, and it just sort of extends the time period that protection applies for.
Thanks, Amy. Right, one final question for Amy, and then we will just cover off a couple of things before we finish up today's session. So a quick question in relation to the neonatal leave. We might not have this information through yet, but would pay be a statutory amount limit similar to SMP?
So I believe so. So it's expected that it will be similar to the SMP payments, but it's not confirmed as of yet. But I'm expecting that it'll be similar, yes.
Thanks, Amy. Thank you to everybody who asked questions. I think that was a really interesting session. So just a couple of things before we finish within the next few minutes. So I just wanted to point you all in the direction of our Knowledge Centre. It's easy to find in the main menu on our website, and it's packed with lots of helpful resources, including all of our upcoming webinars, guides, blogs, and everything on there is free to download. So if you haven't visited the Knowledge Centre, please do. There's loads of information in there. Our employment law legislation guide has a lot of the information that we went through today as well. So if you download that, you'll also have that to refer back to, as well as the slides from this session. And I quickly wanted to draw your attention to our new mobile app. We've recently created an interactive demo site of our mobile app. That means on our website, you can explore the mobile app as an employee and discover its user-friendly features without having to download it from the App Store. And you can try it by using the address that's shown on the screen here. And one final thing in relation to our HR services, I wanted to share a little bit of information. So our advice line runs 24/7, 365 days a year. So no matter when an HR issue crops up, best practice employment law advice is always available over the phone at any time, and it's delivered by our highly experienced team of qualified experts. If you would like to find out more about our HR and employment law services, then do drop me a question in the question panel now, and I can ask one of my colleagues to contact you with further information. So I think that brings us to the end of what's been a very insightful session this morning. So thank you very much to Jackie and Amy for presenting this morning. It's been extremely useful. As I said, I will be following up with a recording and a copy of the slides, so you will have that to refer back to. And thanks for everyone that's joined this morning. And we will hopefully see you at another webinar in the coming future. Thank you, everyone.